Good morning. We have with us Srimati L. Jayanti, Assistant Director, NAS in Chennai. Good morning, Madam.
Good morning, Satyabama.
In our previous video, we saw the first and second stages of appeal under GST. Can we now explore about the procedures for filing appeal with the Hon'ble High Courts and the Hon'ble Supreme Court under GST law?
Sure, Satyabama. Let us talk about the procedure to file an appeal before High Court and Supreme Court under GST law today. Let us first go with the procedure of filing appeal before High Court first, and then we will talk about Supreme Court. In High Court, the orders of appellate tribunal, which involves a substantial question of law, only will be entertained. We will see later about what is a substantial question of law. Section 117 of the CGST Act deals with the provisions of filing an appeal before High Court.
Can you tell us the statutory provisions governing appeal before the High Court?
Yeah, I will. Section 117 of the CGST Act specifies the procedure to file appeal before the High Court, and the provisions of Code of Civil Procedure 1908, that is CPC, relating to appeals to High Court will also apply as far as possible to such appeals.
What are the orders that are appealable?
An appeal lies to the High Court only against an order passed by the state bench of the GST Appellate Tribunal, that is the GSTAT. No appeal lies to the High Court against an order of the principal bench of the tribunal. Such appeals will directly lie before Supreme Court under Section 118 of the CGST Act.
Who can file appeal and which form should they use?
Any person aggrieved by the order of the state bench of the GSTAT may file an appeal. This includes a taxpayer, the department, and any other person adversely affected by the tribunal's order. Form APL 08 is the prescribed form for appeal before the High Court under Section 117 of the CGST Act. It is used by the aggrieved taxpayer as well as the department to challenge an order passed by the state bench of the GSTAT, provided the appeal involves a substantial question of law. This has been prescribed under Rule 114, Sub-Rule 1 of the CGST Rules 2017.
What are the grounds for which appeal can be filed?
The High Court will entertain the appeal only if it involves a substantial question of law. A substantial question of law is a question of law that is important, debatable, has a material bearing on the rights of the parties and is not already settled by law. So there should be a point to debate. Only such cases will be entertained by High Court, and that too it should be legally debatable point. There is a judicial interpretation by way of a judgment of Supreme Court in Sir Chunilal V. Mehta and Sons Limited versus Century Spinning and Manufacturing Limited. There it was laid down that a substantial question of law, it should be of general public importance, or it should have a direct and substantial effect on the rights of the parties, and it should be an open question, not finally settled by the Supreme Court or Privy Council, or it should not call for discussions of alternative views.
Can you give us some examples for that?
Sure, Bama, I will. Incorrect interpretation of the CGST Act or rules, constitutional validity of provisions, conflict between judgments, jurisdictional errors, wrong interpretation of exemption notifications, incorrect application of legal principles. Particularly, questions relating purely to appreciation of facts or evidence is generally not entertained by High Court.
What is the time limit for filing appeal?
Appeal must be filed within 180 days from the date of receipt of the tribunal's order. However, if there is a delay, it will be condoned by the High Court only when there is a sufficient cause for such delay, and such cause should be established.
What is the monetary limit for filing departmental appeal with the High Court?
Cases involving less than 1 crore cannot be appealed before High Court. So the lower limit for filing an appeal is 1 crore.
Can you tell us the procedure for filing of appeal?
Yes, as already told, appeal should be filed in APL 08 and it should be verified in the prescribed manner. and the appeal form should be accompanied by certified copy of the tribunal order, memorandum of appeal, list of dates and events, synopsis, affidavit, wakalatnama or authorization, court fee as prescribed under the respective High Court rules, and copies of relied upon documents should also be annexed to it. The exact filing procedure may vary according to the procedural rules of the High Courts concerned.
What are the points we should bear in mind while drafting the memorandum of appeal?
The memorandum should contain details of parties, jurisdiction, limitation, facts of the case, tribunal's findings, specific substantial question of law, grounds of challenge, and finally prayer.
What is a prayer and how should it be?
Prayer means the appellant is praying to the High Court, that is, he is appealing to the High Court to admit his appeal, formulate substantial questions of law, and to set aside or modify tribunal's order, and to grant him consequential relief, in some cases to award costs.
Now that the appeal is drafted, what is the next course of action?
Once the appeal is drafted and it is filed, next comes the admission stage. At the admission stage, the High Court examines whether the appeal raises a substantial question of law. If satisfied, it admits the appeal and again it formulates the substantial question of law. So the appeal is thereafter ordinarily heard only on these formulated questions, although the court may hear additional submissions or additional grounds when the hearings happen.
How does the hearing happen in High Courts?
During the hearing, the appellant argues the formulated substantial questions of law. The respondent may contend that no substantial question of law arises and may also submit his contentions. The High Court then examines the legal issues and applicable precedents. The High Court does not ordinarily reappreciate evidence and does not allow findings of fact unless they are perverse or arise from an error of law.
What are the powers of the High Court?
The High Court may affirm the tribunal's order or reverse or modify or even remand the matter. It may decide issues not determined by the tribunal. It may correct issues wrongly determined due to an erroneous legal interpretation, and it may sometimes award costs.
Can you tell us how the case is heard and what is the constitution of the bench?
Every appeal under section 117 is heard by a bench of not less than 2 judges. Where the judges differ, the point of difference is referred to one or more other judges. The matter is decided according to the opinion of the majority.
What is the effect of the High Court judgment?
After the High Court pronounces judgment, the GST authorities concerned implement the judgment based on the certified copy. Necessary consequential orders such as refund, demand modification, or even fresh adjudication are passed in accordance with the judgment. Form GST APL 04, which is not an appeal form and it is a summary of the demand after the issue of an order by the appellate authority or revisional authority or any court. This is the prescribed form under Rule 109B, 113.1 and 115 of the CGST Rules 2017.
When is it issued?
Once the appellate order is passed, the form GST APL 04 is prepared to record the revised demand arising from that order. It updates the demand in accordance with the appellate or revisional decisions.
Is there an avenue for further appeal?
Yes, definitely. An appeal lies before the Supreme Court against the orders of the tribunal's principal bench under section 118 or against a High Court judgment under section 117, where the High Court certifies the case is fit for appeal to the Supreme Court.
Can you just summarize the key points for examination?
Yeah, I will do. The provision governing appeal before High Court is section 117 of the CGST Act 2017. The orders which are appealable before High Court is the order of the state bench of the GStat. And the period within which an appeal should be filed is 180 days from the date of receipt of GStat's order, which is condonable when sufficient cause is established. And the nature of appeal should be, it should involve only a substantial question of law. The bench comprising at least 2 judges will hear the case, and once the order is decided, further appeal lies only before Supreme Court.
Can you please elaborate the procedure for filing appeal with the Hon'ble Supreme Court under GST law?
Yes, as a corollary to High Court's order, an appeal to the Supreme Court will be filed under the GST law. This is the final statutory appellate remedy anybody has. It is governed by Section 118 of the CGST Act 2017. The provision provides for appeals from specified orders of the GStat and certain judgments of the High Court.
Which are the orders that are appealable before the Supreme Court?
An appeal lies to the Supreme Court in 2 cases. One arises from the order of the principal bench of the GST tribunal. A direct appeal lies to the Supreme Court against any order passed by the principal bench of the GStat. And second is the appeal from the High Court. An appeal also lies against a judgment or order of the High Court delivered under Section 117, provided the High Court certifies that the case is fit for appeal to the Supreme Court immediately after pronouncing its judgment.
Who can appeal before the Supreme Court?
Again the same order, likely a taxpayer or a commissioner on behalf of the department or any other person aggrieved by the order can appeal before the Supreme Court.
Can you tell us on what grounds can an appeal be filed?
Yes, Supreme Court generally examines questions involving interpretation of provisions of the GST Acts, constitutional validity of statutory provisions, jurisdictional issues, place of supply disputes, conflicting interpretations of law. Supreme Court ordinarily does not interfere with pure findings of fact unless such findings are perverse or based on an incorrect application of law.
What is the time limit for filing appeal?
The GST Act itself does not prescribe a specific limitation period for filing an appeal before the Supreme Court. So, the limitation is governed by the Supreme Court Rules 2013 and the Limitation Act 1963 as applicable to civil appeals. Generally, 60 days from the date of the High Court certificate of fitness. For direct appeals from the principal bench of the GStat, the limitation is governed by the applicable provisions of the Supreme Court rules, which is 90 days. The Supreme Court may condone delay on showing sufficient cause.
You mentioned about the certificate of fitness by the High Court. What if the High Court does not issue the certificate of fitness? Is there any other alternative for the department?
Yes, in such cases, the department cannot go on appeal before Supreme Court directly. It may seek special leave to appeal under Article 136, which grants the Supreme Court of India discretionary power to grant special leave to appeal against any judgment, decree, sentence or order of any court or tribunal in India.
What is the monetary limit for filing appeal with the Supreme Court by the department?
The lower limit for filing an appeal before the Supreme Court is 2 crores.
What are the documents required to file appeal?
The appeal is ordinarily accompanied by Memorandum of Civil Appeal, certified copy of the impugned order, certificate of fitness where appeal is against a High Court judgment, synopsis and list of dates, statement of facts, grounds of appeal, wakalatnama and affidavit. Court fee should also be paid and it should be certified. And relevant annexures and documents which are relied upon should be enclosed.
What are the points to be borne in mind while drafting the Memorandum of Appeal?
The Memorandum of Appeal should contain cause title, jurisdiction, facts of the case, and then questions of law should be formed, grounds of challenge, relief sought should be clearly mentioned, and interim prayers, if any, should also be mentioned in clear terms.
Can you please elaborate the filing procedure?
The procedure involved in filing an appeal before the Supreme Court is, it starts with obtaining the certified copy of the impugned order, then memorandum of civil appeal should be prepared, all annexures and supporting documents should be compiled, prescribed court fee should be paid, then the appeal should be filed before the registry of the Supreme Court. If the registry points out any defects, it should be cured. Then finally, diary number and regular registration of the appeal should be obtained from the Supreme Court registry.
How will an appeal be admitted?
At the admission stage, the Supreme Court examines first whether the appeal is maintainable, and then if the case involves a question of law, and whether notice should be issued to the respondent. If satisfied, the Supreme Court admits the appeal and issues notice.
Is there any requirement for pre-deposit as in the case of first and second stages of appeal?
No, the appellant need not pay any pre-deposit, but don't be happy. He has to pay his entire tax liability before filing an appeal in the case of High Court as well as Supreme Court.
So the next course is hearing. How does that happen?
After admission, both parties file their written submissions. Then the court hears detailed arguments. Then relevant statutory provisions and judicial precedents are examined. And finally, the court interprets the provisions of the GST law and settles the legal issue.
What is the effect of the Supreme Court's judgment?
The judgment of Supreme Court is the final and binding on all courts and authorities in India. It is binding on all GST authorities under Article 141 of the Constitution, which declares that the law laid down by the Supreme Court is binding throughout the country. The jurisdictional GST authorities must give effect to the judgment by passing consequential orders wherever required.
What are the key examination points for filing appeal before Supreme Court?
First thing is, appeal before Supreme Court is governed by provisions of Section 118 of the CGST Act. A direct appeal can be filed over the orders issued by the principal bench of the GST, and wherever High Court orders are to be contested, appeal can be filed only if the High Court certifies that it is a fit case for appeal. The procedure which governs all these appeals are Supreme Court Rules 2013 and the CPC. The issues which can be appealed should involve substantial questions of law or constitutional or legal interpretation should be debated. And finally, the judgment pronounced by the Supreme Court is final and binding under Article 141 of the Constitution of India.
Can you just illustrate the flow of appeal under GST?
Yes. Actually, the appeal starts from the order in original issued by the adjudicating authority. A person who is aggrieved by the order in original has an appeal forum which consists of Joint Commissioner or Additional Commissioner or Commissioner of Appeals, and an appeal can be filed against the order in original as the case may be. Then comes the second appellate authority, which is the GST, that is the GST Appellate Tribunal, and orders of Commissioner Appeal can be appealed against before the tribunal. When an order is issued by the GST state bench, the appeal lies before High Court, and if an order is issued by the principal bench, then the appeal lies before Supreme Court. If a person is aggrieved by the order of the High Court, then again appeal lies before Supreme Court, which is the final authority, and any order issued or any judgment pronounced by the Supreme Court becomes binding on all authorities, and it is the final judgment.
Thank you, Madam, for throwing light on the procedures involved in filing appeal with the High Court and the Supreme Court. I am sure the viewers would have been immensely benefited out of it. Thank you once again.
Thank you, Satyabhama, for the opportunity and as well as your patient listening and your keen interest in learning.
Thank you.